Good afternoon, everyone. It's not quite 2 o'clock, but we'll reconvene the hearing of submissions on Dunedin City Council's Plan Change 1, minor improvements for non-heritage items. So just before we turn to our submitters, anything for us from the reporting team this afternoon? No? Excellent. All right, our first submitter is Health New Zealand, so you sit at the table. Good afternoon and welcome. Thank you very much to you both for pre-circulating your written evidence, which we've read, so you don't need to read it out loud to us. But you're very welcome to highlight key points that you wish to draw to our attention, and then we'll see if we have questions for you. Other than that, up to you. Maybe you can just start by introducing yourselves to the hearing, and we'll introduce ourselves as well. I'm Rob Van Voorthausen, Independent Hearing Commissioner based in Napier.
Sophie Barker, City Councillor and RMA Commissioner.
Jim O'Malley, City Councillor and RMA Commissioner.
All right, thanks.
Good afternoon. Commissioner, Councillors Morris Dale, Planning Support from the School, representing Health New Zealand, and with me is Brendan Shanks, an acoustic engineer with Marshall Day. Happy to run through a summary of our evidence, if that would be helpful, and then happy to answer any questions you have.
Great, thank you.
Should we start with Mr. Shanks first?
Yeah, I think so, yeah.
So I'll just do a very brief summary. We agree that a change to the vibration limits is required. The existing limits are very permissive and would allow unreasonable levels of vibration. The proposed rule, however, has removed the distinction between amenity effects and building damage effects. So having two sets of limits would acknowledge that there's a difference between the onset of those potential effects. So there was some guidance provided by Styles Group that suggested two separate limits, one using a German standard for building damage and another set of limits for the onset of amenity effects. The proposed rule has simplified that and removed that distinction, which I believe is inappropriate. So Mr. Dale and I have drafted a replacement rule to bring back that distinction between those two onset of effects, and also to provide some flexibility to allow the best practical option to be used for construction activities. The Section 42A report has largely addressed my concerns, or our concerns with that, by bringing back amenity, or suggesting amenity and building damage limits separately, and referring to the German standard again. So we've proposed a rule that has some modifications to that, but largely it's in line with the Section 42A report. I guess the key elements of that are not to try and simplify the German standard that has been tried several times in this process and just creates uncertainty, to ensure that there's appropriate measurement and assessment positions in the rule, to ensure that an exceedance does not trigger a non-complying activity, and to allow flexibility to adopt the best practical option when doing construction work.
All right. Thank you, Mr. Shanks. Let's see if we have questions for you.
I did have a question around, I thought that I saw in there that you want an exception for nighttime work. Did I read that correctly?
There's an exception for nighttime work in the road corridor.
On the road corridor, yeah.
Now, I would point out that there's a typo in our recommended rule there, which has the AM and PM around the wrong way. So it should be from 10 PM to 7 AM. The reason for that is the proposed rule has a very stringent vibration limit for nighttime to protect sleep amenity. That would be overly restrictive on work in the night in the road corridor, which often has to take place at night because of practicality of traffic. So it's appropriate to have an exemption for that.
Oh, just the extension that obviously if you're talking about the new build here at the hospital, it's in an area that's not a high residential area as well. Right? In terms of nighttime activity.
Yes, I mean there are some sensitive receivers nearby. There's some accommodation buildings that
could be affected
by this rule.
Ms. Jenks, just your new rule that's appended to your evidence, how consistent is that rule with the rules that appear in other district plans around the country that you're familiar with?
It's reasonably consistent. The main council that's implemented a similar rule is Auckland in the unitary plan, and it's the options that were provided by Styles Group are based on that Auckland unitary plan rule, and it's very consistent with that in terms of the thresholds and triggers that were used.
Were you or your company involved with developing that unitary plan rule?
Sort of tangentially, yes. That rule came about through the CRL project, where there was a lot of sensitive receivers near that project. It has had its teething problems, which we've touched on I've touched on in my evidence, that it has triggered quite a lot of consents for small work, hence the introduction of some flexibility, having 3 days where the amenity limits can be exceeded. So it's not without its complications, and personally I would advocate for the amenity thresholds to be a trigger for management rather than the need for a resource consent. But I appreciate that the planning framework makes that difficult to manage and oversee.
So just in terms of that last point, so the rule you've recommended to us in your evidence, does that address those glitches with the Auckland rule?
There will still be situations where minor works will trigger a resource consent, but having some flexibility in that rule does remove some of the, I guess, the low-hanging fruit in terms of 1 or 2 days of activity that shouldn't really trigger a resource consent process.
I just had one question about the proposed rule, and it's on it's the first page of your Appendix A. And it's condition A bracket I bracket 3, or not bracket 3, it's condition 3 under Roman numerals I, so the text under the first table starts with the word vibration that complies with a limit of 5 millimetre. Have you got them up?
Yes.
Yeah. So I understand the first bit of it, vibration that complies with a limit of 5 millimetres per second PVB, but then unless a lower limit for avoiding building damage in rule 4.5.4.X, great numbers, aren't they? Applies, in which case the lower limit must be complied with. But then when we go down to that 4.5.4.XB, it just refers to the German standard as the vibration limit. So I'm just wondering how usable is that to readers of the plan? They would need to get expert advice from someone who first of all knows where that German standard can be obtained from, and then knows it well enough to read it and determine what, if any, lower standard applies. Is that very practical?
I think the reality is, with assessing vibration, it's a specialist field anyway, and you're going to be seeking specialist advice from someone who can access and understand that German standard. And as I said earlier, the attempts to try and simplify that German standard into a table to something more simple in the rule have just introduced complexities and uncertainty.
All right, so in terms of B, it refers to Part 3, effects on structures of that German standard. Is that a sufficiently precise cross-reference, or are there like particular subsections within Part 3 that are more relevant than others, or is it better just to refer to Part 3 in its entirety?
It's better just to refer to it in its entirety. Within that standard there are different criteria for long-term, short-term vibration, and some of the rules have frequency-specific content with them. So again, to try and condense that down into something within the rule is going to just cause more issues.
And have you had a chance to discuss your proposed rule with the author of the Styles report?
I haven't, but we're largely in agreement on most elements.
Probably be helpful for us if you could share the rule with the author of the Styles report and just ask for their feedback on it. And then if you could provide any feedback received to our reporting officers, and then they can take that up in their reply report. And it'll just give us some comfort if we knew what the council's advisor thought about your rule. I don't think that hasn't already occurred, has it? Or?
We have actually.
You've done that? Okay, so you don't have to do it because I've already done it. Okay. When's that expected to come in?
We expect it to come in
I'm more than happy to liaise with Mr. Exeter from Styles Group if he's got any questions around our rule as well. That's
Yeah,
to do.
that'd be good. I think I'm happy for you to independently contact Mr. Exeter, just confirm he's received the rule from the reporting officers.
Yeah.
And if he has any issues he'd like to discuss with you, you should encourage him to do that. And then perhaps Mr. Exeter can just record the outcome of that as information that he gives to you, Peter, just to bring certain profiles. Yep, good. And if peace can break out, that would be great. But if not, it'd be good to know what the areas of disagreement are.
I mean, we agree on most things, which is a good start.
Okay. Did you have another question?
Yeah, around the calculating the vibration levels, because it talks that your recommended replacement rule reflects an approach which is a minor change from what was recommended by Styles for option 2, and that's where the vibration is measured. And I just wonder if you could expand on that a little bit.
Sure. So the proposed rule includes an assessment position which is on the foundation or in the corner of a building. So that's appropriate for structural, for building damage assessments. However, the effects of vibration amenity would be measured across the floor plate of a building. So there's changes in vibration as the vibration comes through the ground into the building and then into the building structure. So what we've recommended is that the vibration is calculated to the ground outside the building, which assumes that there's no losses into the building and is in most cases a conservative approach, because the vibration in the building will usually be less than the vibration in the ground outside. And then when you measure the vibration, you measure it in a position where people would be affected by vibration, which is inside the building. So there's a difference between the position that you calculate to and where you measure. The reason for that is to try and calculate the vibration within a building is a highly complex process. You need to understand the foundations of the building structure, the resonance in the floor slabs, which is just an impractical thing to do when you're assessing construction vibration.
Okay, thank you.
So those are calculations rather than measurements? Because it's all, yeah.
Well, so in our proposed rule, we've set out an assessment position or a calculation location, which is just in the ground. So that takes a lot of those building variables out of play. But then when you're measuring the vibration, you actually measure it inside the building.
Right. And that'll be depending on the structure of the building and everything, right?
Correct. And in most cases, the vibration inside the building will be less. There will be some cases where there's building amplification, and in that case, you've measured inside the building and actually measured the received vibration.
Thanks.
All right, thanks, Mr. Shanks. Mr. Dale.
Good afternoon. So Health New Zealand. Health New Zealand opposed the proposed vibration rule due to the impact of the vibration limits, including discretionary and non-complying status for contribution of those limits, due to the impact on its ability to develop, use and upgrade hospitals and healthcare facilities. Based on the evidence of Mr Shanks, I consider the proposed rule that proposed by Council is inefficient as it results in more restrictive limits being imposed than are necessary to address amenity effects and the risk of cosmetic building damage. Also results in more resource consents being required for construction and site investigation activities than is necessary, and applies a discretionary or non-complying status for contravention of the limits, which is inappropriate given the unavoidable and temporary nature of construction activities. The replacement rule recommended by Mr Shanks, I consider will be a more effective, efficient and appropriate way of achieving the objectives of PC1 and 2GP, as it will better align with appropriate technical standards, ensure limits are applied at a level that is appropriate to the onset of effects, and result in consent only being required where necessary to ensure protection of amenity and to avoid the risk of building damage. I consider restricted discretionary activity status for contravention of the limits, coupled with relevant matters of discretion, will provide the Council with the ability to appropriately manage vibration from construction activity, and it's not necessary for a discretionary or non-compliant status to be imposed.
All right, thank you, Mr Dale. So if you have questions, do you have questions, Mr Dale? Mr Dale, I just had one question for you, which I'm happy for either you or Mr Shanks to answer. It's just in your paragraph 8.4. And you say there that replacement rule proposes building definite limits that are less stringent than those in the proposed rule, but which align with the limits in the German standard for sensitive structures that are of great intrinsic value. Now, I couldn't see a reference in the proposed rule to sensitive structures that are of great intrinsic value. Is there a reason for that?
So that relates to, perhaps. So that relates to the building damage limits, which is in clause B of the replacement rule attached to Mr Shanks' evidence. And the reference to buildings of great intrinsic value is referenced in the German standard specifically.
Yeah.
So it's not, the reference isn't included in the actual proposed rule, but it is in the German standard.
So is that located in part 3, effects on structures of that standard, is it?
Yes. It's in table 4.
So either you or Mr Shanks, is there a need, do you think, to highlight that? Or is it, I mean, I asked earlier if it's all right, if it's appropriate just to refer to part 3 in general, but given Mr Dale's evidence, is it appropriate to highlight that particular part or not?
I mean, I think when you're implementing that standard, if you're doing an assessment based on that standard, then the first thing you look at is what's the type of building you're assessing to, and there's 3 building types within that standard. So that, I don't think there's a need to be specific about that in the rule. If you're implementing that standard, you'll be looking at the kind of building that's receiving the vibration.
Okay, so Mr Dale, that's all I wanted to ask you about. Just check, don't have any follow-up questions. All right, thank you very much to you both for coming in and for the evidence you prepared and answering our questions. And Mr Shanks, look forward to a little bit of further working liaison you're going to do with Mr Exeter and your results.
Thank you.
Thank you.
Our next submitter on my list is Fire and Emergency New Zealand.
No, we're way ahead of schedule, aren't we?
Pardon? Yeah, well, yes, and maybe if you could get whoever's online, can you email them and just ask them if the one who's supposed to be here in person could just come in earlier? That would be good. Yep. So now we'll adjourn until we're ready to hear from Fire New Zealand. Reconvene the hearing of submissions, and at this stage we're hearing from Fire and Emergency New Zealand. I think we have Mr James Knapp present in the room and hopefully Mr Paul McGimpsey on Zoom.
Hello.
Yeah, good afternoon. So you can hear us all right?
I can.
And we can see and hear you.
Oh, that's good. Okay.
All right, so thank you very much. We've received and read the written statement that was co-authored by the peer review, so you don't have to read that out loud to us, but we're very welcome. You are both very welcome to speak to that and highlight key points, and then we'll see if we have questions for you. And I don't mind who goes first. I'll leave that up to you.
I'm going to defer to Paul as the main driver of the submission.
Sorry, James. You'd like me to go first?
Yeah, here you go, Paul.
Yeah, sure. Well, good afternoon, everybody. As you said, the written submission has been received and read, so I don't propose to go back through that. All I was sorry, I should introduce myself. I'm a planner, and James in the room is Community Risk Manager from Fire and Emergency. I would note that the written statement is not a statement of evidence, it is just a written statement. Hopefully the written statement sort of explains the fact that there was I suppose what we might call a small, perhaps miscommunication, which seems to have started with 2 Fed submissions being lodged, unbeknownst to each other. Probably the key thing perhaps, and I'm not sure how across the hearings panel is, was I received an email this morning from one of the policy planners, Bede Marisi, with some proposed changes to the wording around Rule 9.3.3, as well as some questions around the implications of low pressure hydrants that James will be able to speak to. Appreciate that only landed with me and James this morning, so I don't expect that you will have had a chance to look at it.
So not only have we not had a chance to look at it, we haven't received it.
That, or whether that's just a little bit too fresh. I guess really the purpose of James and I here showing up this afternoon was whether you had any further questions based on our written statement from last week that you wanted to discuss, really.
No, look, we haven't received the proposed redrafting that you just referred to from Mr Bede, was it? So we've got no idea what's being proposed there, which is not the best. But in terms of your written statement, I'll just see if we have any questions for you. But Mr Knapp, did you want to add anything before we go to questions?
I have got the proposed drafting in front of me if we do have time to get to that. But yeah, no, I've got nothing to add.
So when you say the proposed drafting, is that the drafting that Mr Gimpsey referred to that he just received in an email today?
Yeah, from Bede Morrissey, Policy Planner, City
Right.
Development.
Well, we haven't received that, so I don't know how much merit there is in with you going through it, because we don't know what it says. So what I'll do is I'll see if we have questions for either of you from the written statement, and then we'll decide what we're going to do about this late breaking news with the staff proposing some amendments that we're not party to. So any questions from the written statement?
I guess my question relates to 9.3.3.1 around it almost being a loophole, and is that the thing that you are most concerned about?
Yes, primarily, yeah. And as at the last couple of lines in a written statement was a key point really, that although we were consulted early on, we didn't fully realise the implication of the deletion of that, which would exacerbate the existing gap between residential and non-residential subdivision activities.
Yeah. So in a nutshell, just in layperson terms, is it your case that 9.3.3.1 is kind of deficient, but it's better than nothing? Is that?
That would be a fair summary.
Yeah. All right. And do the changes you've received from the council planner today, do they look to address those deficiencies in your view?
Yeah, on the face of it, it would. The proposed redrafting would address our concerns.
And does that redrafting see the retention of 9331 with amendments?
No, it actually proposes to amend Rule 9.6.2.x.
Right.
to remove the words that may result in new residential buildings, so
Right.
leaving subdivision activities.
All right, so from Fire and Emergency New Zealand's point of view, that would be satisfactory. All right, so maybe Mr McGimpsey, if you're of a similar view, if that could be conveyed back to the council planners, and then Mr Rawson, you can include that advice to us in your reply report. But I'd also like you to address an issue of scope, if there's scope to amend a rule that hasn't actually been altered by Plan Change 1.
Yes, absolutely. I have to say, Dean Morrissey with fund fans, but also other smithers who in regards to the firefighting rule. So it's just trying to liaise with them prior to our right to apply. So
Yes.
together with which I would agree with. So it's still in draft form. We're still working through it as we speak.
Yeah. Now, I appreciate the liaison that's going on. It's just a bit not really appropriate if a submitter comes before us with redrafting that they wish to address to us and we've got no idea what it says.
Yes, I understand.
All right, so Fire and Emergency New Zealand, I think...
Sorry, if I might just say as Fire Emergency's planning consultant, having a look at the draft wording provided this morning by Mr Risi, and he does emphasise it is only rough wording. My planning opinion to Fens would be that it achieves the relief that's ultimately being sought around the retention of firefighting water provisions to non-residential subdivisions. So, for what it's worth, from me, a support in principle.
Okay. All right, well, it's encouraging for us that liaison is going on and that a solution appears to be evident. So notwithstanding my concern that we don't know what it says at this stage, I do appreciate that work has occurred. So we thank both the planners and Fens for doing that. And we look forward to seeing that wording in due course, Mr Rawson.
Absolutely.
All right.
Okay, thank you.
Thank you both very much.
Thank you.
Thank you.
So our next submitter is Malcolm Burns. Well, we'll see. So you're Emma Peters.
That's correct, yes.
Now we've received just this afternoon a 11-page statement of evidence from you and an attached 49-page Environment Court decision, which wasn't pre-circulated. Minute 2 that we issued for this hearing required expert evidence to be provided by the 1st of August. You're now 13 working days too late, so why should we accept your evidence?
Yes, I accept that it's late. The Environment Court decision is the one that you should already have anyway. It's referred to in both the Section 32 and Section 42A report. Both rely and discuss it in terms of the justifications for change RU7, which is what Mr Burns' submission is about. So in terms of the evidence that's there for you guys to accept or read as that's entirely your decision. I've put a summary statement which I can speak to today, which just outlines the main points, and then it's obviously up to you guys.
Why is your evidence so late, and why haven't you sought leave to have it provided late?
Sheer workload over the last period. It's been an extremely busy period. I'm essentially a one-man band, and this matter I have undertaken on a pro bono basis, and so my paid work had to take precedent. There's been a lot of conflicting deadlines that I've had at the same time, so I just simply apologise for the lateness. Yeah.
It sounds very familiar to the reasons you gave at the future development strategy hearing for your late evidence at that stage. Ms Peters, I'd suggest to you, you really need to look at the way you operate and not take on work that you can't do within the appropriate timeframes. It's really inappropriate for a supposed expert witness to be coming in with evidence so late, providing it on the day and expecting a hearing panel to give it due consideration. It's just not good practice.
Yeah, no, I accept that, that's fine, yeah.
Well, it's not fine, but it's good that you accept it.
Yeah.
So what I suggest you do is you can read out your summary statement, and then we'll read the balance of the evidence in our own time and refer to the Environment Court decision in our own time.
Absolutely. So obviously this submission seeks a decision which rejects change RU7. Change RU7 is to do with the policy pathway, consenting pathway provided by 16217B. So that's residential activity on undersized rural zone sites, where that residential activity is associated with long-term land management and or capital investment that will result in significant positive effects for rural productivity or a significant contribution to the enhancement or protection of biodiversity values. Now, change RU7 is only in relation to the second of these, and it seeks to narrow the circumstances in which this exception to the avoid policy will apply, and the justifications really all stem from the Environment Court case that we have, that you've mentioned before. So the Section 42A report for this matter recommends rejecting submission 63, but what I've laid out is that essentially the analysis in the Section 32 and therefore report, and therefore the Section 42A report is unsound, and there's several reasons for that. So the land use consent application resulting in the appeal, the Environment Court case, was supported at the council level at a non-notified hearing by a Section 42A report recommending grant, with that recommendation maintained at the hearing. And ultimately that recommendation was proven right at the Environment Court level. The Section 32 report and Section 42A report don't make a proper analysis or take into account the court's findings based on the court's preference for the ecological evidence of Dr. Calvin Lloyd over that of Mr. Scott Hooson. The court found that Mr. Hooson was unduly influenced by the requirements of a significance assessment in the context of Section 6C of the RMA. There's no analysis in the Section 32 or the Section 42A reports of the fact that most rural land in Dunedin is situated within ecologically degraded land environment, shown as red, which is less than 10% Indigenous cover left, orange 10 to 20% Indigenous cover left, or yellow 20 to 30% Indigenous cover left. According to the Landcare Research, our environment threatened environment classification. And this is particularly so for the Torrey Plain, which has less than a 2.9% of its original land cover left. No ecological evidence demonstrating how change RU7 will achieve the strategic direction objective 2.23 has been provided in either the Section 32 or the Section 42A report. And it's particularly important in terms of the emphasised part that I've got there, which is, and other Indigenous biodiversity is maintained or enhanced and restored, with all Indigenous biodiversity having improved connections and improved resilience. So the Section 32A report only talks about significant Indigenous biodiversity, and it doesn't provide any ecological evidence with that analysis saying how the change is going to provide for other areas of Indigenous biodiversity and what effect the change will have on that, and seems to rely entirely on the evidence of Mr. Hewson in the Environment Court case. There's also no evidence provided in the Section 32 or 42A reports saying, showing that the court's reasoning in the Environment Court is causing an issue with respect to administration of the district plan. Just earlier this week, I've had council staff have provided information showing that the great majority of the applications making use of policy 16217 use LMA, which is the surplus dwelling subdivisions, and obviously not affected by change U7. And council staff only found 2 land use applications which make use of policy 16217B2. So that's the Wakawaiti case referred to in the Environment Court decision, and then the Environment Court decision itself. The Wakawaiti case came before the Environment Court case 1, and obviously those were both granted, one at council level, one by the Environment Court. And then there's a mixed subdivision and land use application which was declined. This shows there's been no proliferation of applications using policy 16217B2 since the decision in the Environment Court was issued on the 14th of March 2023. And I think this is an important point because the thrust of both the Section 32 and the Section 42A report is that there's essentially be a opening of the floodgates and a proliferation of cases due to the wider interpretation, but this just isn't borne out in fact. The Section 32 and 42A reports make no exploration of the criteria, so both planning and ecological, that a site must meet to avail the consenting pathway in policy 16217B2. So that's things like so the Environment Court case actually helpfully sets out the ecological factors that were in Dr. Lloyd's evidence, and so there's a number of those that are needed. So the site is located on land environments that retain less than 10% of the original Indigenous cover, with higher weighting given to land environments that retain even less Indigenous cover than this. The site is located in the coastal environment. The site includes a natural water body. The site includes or is adjacent to an area of existing Indigenous vegetation. The site contains or would create a significant habitat for Indigenous fauna. And where planting is a part of the contribution, it should be at least half a hectare in size, and that enduring legal protection is provided over the area in which the significant contribution is made. And then the planning factors would be things like availability of legal and practical access, type of instruments registered on the title, availability of a building platform which has a low risk of natural hazards and can be situated in a location desirable for residential activity, sun's views, gradient, and association with ecological restoration, enhancement and or protection. Any adverse effects with respect to reverse sensitivity, cumulative effects, and effects on the rural character and visual amenity that are no more than minor. That's the Section 104D test. And activities required to meet the ecological requirements and quantum of that cost, and the extent, if any, that residential activity will displace rural productivity. That's essentially just the summary of it all, and open to any comments that or questions that come about from that.
Do you have any questions? Ms. Peters, I'm just wondering what the relevance of all of the material you've referred to in relation to the Environment Court decision actually is. My preference is just to look at the utility of the words as notified and to consider whether or not they provide an additional or superior guidance to a decision maker. And in my view, they clearly do. I mean, the existing words relate to enhancement or protection of biodiversity values. Biodiversity values is a defined term. When you click on that term, it's reasonably vague in some respects. and the proposed wording relating to an existing area of important Indigenous vegetation and/or habitat of Indigenous fauna, in my mind, is far more precise and provides superior guidance to a decision maker. So I'm not seeing a problem.
So the problem is that most of the rural land within Dunedin district is ecologically degraded, and so what you're doing is you're only taking essentially into account areas that are probably more at the Section 6C end of the spectrum than the other that is provided for under the current wording of the policy 2.23 or objective 2.23. And so I think that's where the concern is, and the Environment Court case traversed all of this and the wordings, how the terms could be defined or interpreted in any one context. So it's always going to come down to ecological assessment, expert ecological assessment in terms of the significance of the biodiversity values and the contribution that's been made to it.
Yeah, I guess I'm still not seeing a problem that needs to be rectified, but the proposed amendments relate to an existing area of important Indigenous vegetation. I mean, the words "as notified" don't say that has to be within the actual site that's being considered. It could be anywhere in the district. It could involve a contribution to the protection of an existing area that's remote from the site.
But the whole purpose of this policy, the promulgation of this policy, and the reason it ended up in the district plan was a 2GP settlement of a 2GP appeal that was to provide for an incentive for Indigenous planting in areas of ecological degradation on existing sites. So the planting had to be on the site, not on another site. And that the concern from council that's given rise to change RU7 seems to be that you can start from a site with very little ecological value, and that the court found that was true because under the current wording, but that's a good thing. It's not a bad precedent to have, because of the fact that most of our rural environment has very little Indigenous biodiversity left. And so the whole point of this policy is to incentivise rural landowners that can meet the criteria that are needed in order to access this pathway to actually undertake Indigenous vegetation replanting, and in exchange they get the right for residential activity.
All right, well, I don't have any further questions for you. Any follow-up questions so far? No, all right. Thank you very much, Ms Peters and Mr Rawson. Look forward to you addressing this matter in reply. Thank you. Now, our next submitter is not scheduled to 3:30, but are you happy to go now, Mr Page? Or would you rather have a break?
Well, I'd like to do a break from the particular, so I can very much back here, but I'd really rather wait for my time to arrive.
Fair enough.
So if we can wait for 3:30 before
Of course.
whoever arrives earlier, that'd be good.
Yeah, absolutely. So we'll adjourn until your client arrives. Sorry, I didn't realise you were waiting for a third person.
No, that's right. I just wanted to see what was going on before okay, so it's been useful.
Okay. Right, we're adjourned until 3:30 or an earlier time if the University of Otago representative arrives. Right, good afternoon everyone. I reconvene the hearing of submissions on Plan Change 1 to the Dunedin City Council's 2GP, and at this stage we're hearing from the University of Otago. Good afternoon and welcome Mr Page and Ms Taylor, isn't it? Is that right?
Yes.
Yes, so we've received and read already the legal submissions, Mr Page, and also the planning evidence, Ms Taylor, so thank you very much for doing that. And as you'll know from previous hearings, we have actually read it. So, but you don't need to read that out loud to us, but you are of course very welcome to highlight key points that you wish to make, and then we'll see if we have any questions for you. So other than that, over to you.
Good. Thank you, Mr Chair and Commissioners. We are grateful for the opportunity to come and do that. What I will do is address at a high level the 2 points that are really made. The relief that we seek is extremely narrow, in 2 extremely narrow points. We want to disapply the the high trip generation trigger to student hostels, and you will know that that has already been disapplied to campus activities within the campus zone. So student hostels remain something of an outlier in the treatment of HTGs. So we could build a laboratory facility that has 400 or 500 students going in and out all day, and the HTG trigger wouldn't be applied, but the same number of students accommodated in a hostel would trigger HTG. So if you think about the Te Rangihiroa college that is the most recent construction down at Anzac Ave, that would have triggered the HTG requirements that have been introduced through PC1, so that's why we're interested. The second is in relation to disapplying Rule 454X insofar as scheduled heritage buildings on the same site is concerned. So in other words, for the university, what we're talking about is, do we have to comply with that rule when we're working within the campus zone on our own buildings? So those are the 2 things that we want to address. You've no doubt tracked through my opening submissions how the university sees the interplay between the Chapter 2 objectives in the 2GP. And what we say is, when you look at the scope of what PC1 is trying to do, it is not to change those objectives or the way they operate between each other, but rather simply deal with implementation issues, which are called minor improvements, and you can see what I think about that name. But anyway, it's very much a plan change that is not about changing the direction of travel for the 2GP, but how it's given effect to. But what we say is happening when you look at the HTG trigger rule is that it is converting student hostels within the campus zone from a controlled to a restricted discretionary activity. And so we're only talking about within the campus zone here. We accept the application of the rules for colleges outside of the campus zone, so in the residential zones by and large, or the mixed-use zones around campus. That's fine, we don't have a problem with that. It's only within the campus zone we're talking about. So what the university is saying is that the campus zone has been set up specifically to enable the university to operate efficiently. It gets to decide where is the right place for colleges within the zone. And if you look at the way that policy 622Y is now framed, and the rule that falls out of that, and you can find that at paragraph 22 of my submissions, it tips the priority between the transportation network and the campus zone on its head. What it's effectively saying is that the campus zone has to be managed to enable the efficiency of the transport network rather than the other way around. And that is because the policy says only allow high trip generators where the activity is located, and it sets out a bunch of criteria. So that's telling you what the most important resource is, and it's telling you the most important resource is the transportation network, because you only allow things when the transportation network issues are resolved through A and B. Now, Carmen's evidence goes on to talk to you about the assessment matter that falls out from that, but it's the reversing of the operation between the objectives in Chapter 2 that's really what the university is concerned about. It says that it accepts that transportation matters are relevant and they can be controlled through conditions, but not at the expense of granting or not granting a resource consent for a new college within the campus zone that was set up for the very purpose of allowing just that. So that's the gist of the issue for the university in relation to HTG. We're not saying we want to get out of jail free. We know that we will cop conditions through resource consent applications for controlled activities that deal with transportation and parking, but we say converting that from a controlled to RDA is the wrong approach. And it's not mandated by the objectives that Chapter 2 sets up for the campus zone in the first place. So weirdly, when you think about what reverse sensitivity is, and the objectives specifically address reverse sensitivity and protecting the campus zone from it, the transportation network becomes a source of reverse sensitivity on activities within the campus zone. That's the points that we want to make. I want to make anyway for the high trip generation network. To address the second issue, which is in relation to the vibration standard, what I want to do is to take you on a bit of a journey through your documents. And I presume that you have the Section 32 and 42A reports available to you on your screens. So if we could start with the section, there's two styles group reports. One was an appendix to the Section 32 report, and there was a second one that was to the 42A. So if we could come to Appendix 6C to the Section 32 report, that's the document that discusses how the German DIN standard works. And there's a couple of features to that I want to point out to you, which hopefully will all come together at the end and explain why the university doesn't accept the application of the DIN standard to buildings on its own site. So firstly, if we can come to page 6 of Appendix 6C and give me a nod when we've got there. At the top of page 6, it starts with a paragraph numbered 1, the British Standard BS 5228. There we go. Thank you, Roxy. So, the third paragraph makes clear what the German DIN standard does. And you can see the first paragraph, the second sentence, DIN 4150/3/2016 takes a different approach and provides guideline limits for transient vibration below which cosmetic damage will not occur. So that's key, because that explains the degree of damage to buildings that standard's thresholds are driving at. It's ensuring that cosmetic damage will not occur. And then, if we can stay where we are, Roxy, if you look at the paragraph at the foot of the screen, the guideline values of DON 4153 have been adopted as permitted standards in numerous district plans. And then if we look at the footnote number 2 at the foot of the page, it tells you the two examples which are used. AUP standard 25630 and the QLDC proposed district plan standard. I have studied both of those standards, and every other one that I can find. None of them apply to buildings on the same site. They are all dealing with cross-boundary damage issues. The last part of this document I want to look at is on page 14, Roxy, if you could find your way to there. Okay, yep, there we go. So this is from the option 3, which was advanced by Styles Group. And you will recognise the numbers in the second and last columns as being the standard, which has now been recommended to you, 3 millimetres per second, 2.5 mil standard. What you will see is what those triggers relate to, and this is from the German DIN standard, structures that are particularly sensitive to vibration and are of great intrinsic value. So there are 2 thresholds that the German standard applies to make the threshold triggers appropriate. It is not just that they are heritage buildings. It's that they are of great intrinsic value, and that might be a paraphrasing of heritage, I'm not going to argue the toss about that, but are also particularly sensitive. So there's 2 things the council has to be satisfied about: the sensitivity of the building and its value. We'll give up the argument about value because scheduling's done that, but the council has done no work around the sensitivity of the buildings. And what the university says is, who's telling you that its buildings are vibration sensitive? There's no work that's been done to advise you that the Bluestone heritage buildings that are on campus are particularly vibration sensitive. The university's position is that there's no reason to think that they are. So those are the points that I wanted to draw from the Styles Group's first report. The second report is the 42A report, also Appendix 6C. And so if we can go to page 4 of that. And page 4 is advice that is, yep, that's the right one. Can we scroll down a bit further, please, Roxy? And this is, because it's the paragraph beginning overall which I want to draw your attention to. And this is advice that Styles Group give in relation to the Port Otago submission. Overall, our view is that the numerical values and time periods in the notified vibration standard are appropriate for mitigating effects on the occupants of buildings, but are too low to be used as control for building damage. We recommend that they are not applied at unoccupied buildings or on buildings on the same site as the works, and a separate vibration standard for building damage is applied. And then if we go to page 6, and we go to the foot of the page, and this is advice in relation to the Marshall Day acoustic submission. It says, we do not share concerns about the Auckland Unitary Plan provisions referenced by the submitter. In our experience, the AUP vibration amenity standard can typically be complied with on small construction projects, and a permitted standard should not enable minor effects. Many moderate to large construction projects will require consent for infringements of other permitted standards, and short duration infringements on the vibration amenity rule are generally considered acceptable. The point is that the AUP provisions are set up so permitted standard should not enable minor effects. Now, this needs to be understood in the context that what Styles Group is recommending is not to have a vibration standard that applies to same-site vibration. And remembering that the Auckland Unitary Plan standard, which they were talking to in the quote on page 6, is dealing with cross-boundary damage. And so what they're saying is that the permitted standard, when you're talking about cross-boundary damage, in other words, when you're risking somebody else's building, should not enable minor effects. And that seems perfectly understandable when you think about cross-boundary effects. But why should the same standard be applied to same boundary effects? So the things that I want to draw out from the Styles reports are, firstly, there's no evidence in the technical reporting which is recommending to you that the standard applies to buildings within the same site. It's entirely dreamed up by your planning staff. There's no technical advice about that. The second thing is that the standard has been set up to avoid any damage. So as I've set out in my legal submissions, the university is perfectly happy to accept that the public has an interest in heritage buildings insofar as external alterations and demolition is concerned. But questions about minor cosmetic damage to a heritage building are entirely the university's providence, and the district plan has got no business regulating the effects at that level. So then the last thing I wanted to address, which I raised in my submissions, is that let's actually think about, for an own site rule, how that works in practice. And remember that there's nothing in your district plan which requires anybody to measure vibration on their own site. There's no obligation to monitor, there's no obligation to report. So how would you ever know whether damage to a heritage building has been caused by vibration? Well, the only answer to that is, well, maybe for some other reason, and usually for construction insurance reasons, somebody is actually monitoring vibration. They don't have to report that to you, but maybe they're doing it. And maybe they measure an exceedance during the course of that. And maybe they decide to report that to the council officers and they down tools halfway through a project. Anybody who's done a construction project, alarm bells start ringing about, oh, hang on, how do you then deal with the consenting process in the middle of a project once an exceedance has been identified through monitoring? What is the public interest in causing that degree of regulatory oversight of a construction project when the standard is designed to deal with any minor cosmetic damage to a building? Surely, in the context of the University of Otago, the council can accept that level of interference with a heritage building is entirely its own business. So imposing a rule which would require it to down tools halfway through a construction project and seek a resource consent and kick its contractors off-site, there's no cost-benefit ratio to the public interest that could justify a regime of that kind. But at a practical level, you don't have technical advice from somebody experienced in construction contracting who can satisfy you that the rule is effective and efficient. There's simply a bland statement in the Section 42A report that rules provide certainty. Well, not in this circumstance, they don't. That's all I wanted to say by way of summary.
All right. Let's see if we have questions for you in terms of the legal submissions. Any questions, please?
Effectively, what you're saying is that if you own the buildings, it's on your site, and the buildings are sound, as you're saying that the heritage buildings are, that there's no public good in effectively putting this rule as it relates to the university as it sits at the campus major facilities are.
Yes, there's no public good, because if what we're talking about is a standard which is designed to protect the university from inflicting minor cosmetic damage to its own buildings, that's the university's problem. Completely accept that we can't knock them over, completely accept that we can, well, scheduled ones. Let's not go down that rabbit hole. completely accept that we can't knock over scheduled ones, and we can't exterior alter them. That's where the public interest lies. That's the Section 6B matter that the plan addresses, and in my submission addresses appropriately through Chapter 13 already.
Right. And it's not cross-boundary stuff, it's actually...
No, it's our own stuff.
That's very clear.
Yeah.
I just wonder I tried to find the information about when the campus zone was enacted. I'm looking through and can't find it. Could you give me a date around when it was enacted?
Well, it was in the notified 2GP, and so was it around 2015? Peter will remember. 2015. The brain works on Sundays. Sometimes it's just a bit slow to boot up. But
I'm just thinking about the campus master plan of 2010. So
Yep.
I'm just wondering if there is logic behind that around the HDG. Just thinking about the campus master plan from 2010. I'm assuming that the 2015 master zone was based on that, and that had a strategic direction to get 7,000 students in 25 years, which was up to 2035. And then I see that the strategic plan has been to grow the student cohort by, I think it's 6,000 FTEs by 2030. So what I'm thinking about is the traffic implications on that zone and the building of more hostels, which is kind of what this is about. So I was just wondering when the 2015 2GP was done, this might be exercising your brain a little bit, if that was based on that 2010 master plan.
no, it's more spatial than that.
Okay.
I was involved when the university prepared its submissions on the 2GP when it was originally notified, and days where Murray Brass was the planning manager at the university. The gist of it was that let's identify a location that the university and the poly are effectively managing its own affairs within the fence. And so there was a fair bit of toing and froing to identify where the boundaries were vis-a-vis surrounding zones. But once we settled on that, effectively the policy structure in Chapter 2 and Chapter 34 is, as long as what you're doing within that zone complies with performance standards in that zone, fill your boots up. And the reason for that is that that's the land resource which is identified as having all of the transportation networks around it, the appropriate infrastructure in terms of wastewater and electricity, all that kind of stuff. So go and have your own happy playpen over there and we'll leave you alone. That's the gist of how Chapter 2 and Chapter 34 works. And what we're worried about is that, hang on a minute, that attitude has changed to we want to be able to say no to where you put a college. And that's fundamentally different to the reason why that zone was set up in the first place. The university gets to decide where it builds colleges so long as they're within the zone.
So I want to follow that up in terms of the transport network itself,
Yeah.
which is well out, which incorporates the zone and all the areas around it. And would it not be the intention that when you have the campus zone, it's for activities that entirely are captured inside the zone? Whereas if you have an activity inside the zone that then projects out beyond that into the general transport system, would you not now be affecting beyond the zone? Potentially.
Well, and so that's kind of where Carmen's evidence goes to some extent by saying we're not expecting a complete carte blanche here. The controlled activity framework has traffic and parking as an assessment matter. So we expect to apply for a consent, controlled activity consent, and we expect to work with council on what the conditions are to mitigate the effects on the network. What we don't expect to be told is no, you can't have it.
Right, so it's the status.
And so it's the status issue. It's controlled versus RDA, which is work with us and we'll manage this, compared to we're going to tell you to go away.
And then I have a question, staff. If that status changes, if there's control, would the transport objectives be able to be met or discussed on a city perspective, as opposed to the restricted discussion?
Well, this discretion on states that depending on the discretion when the judges can transport objectives, the council can refuse them.
So it's a balancing of what city intends to go on inside the campus zone in terms of the amount of autonomy it gives to the university collective for them to pursue activities and official means of the versus whether or not the city actually wants to full control of that area. Thank you.
So just in terms of that, under a controlled activity status, I assume decision maker could still impose conditions relating to off-site transport effects and upgrades and things?
Yeah, I guess that's what I'm going.
So the issue could still be addressed, that just the university would have certainty that the primary proposal would be approved, and then they would have to live with whatever conditions are imposed within the scope of the matters of control. Right. So, any other questions on the page?
Just one in terms of a general high traffic generator in general, would it be fair to say that most of the students, especially in the halls, are walking?
Probably.
Yeah. So the anticipated activity, if we're looking at an unknown activity in the future, but the anticipated effect, we could assume that it would be less than say, a hotel where many of the guests may have come by vehicle. Well, given the fact that all the car parks there and most students don't have the cars, that's just
I mean, that would be consistent with my experience, Commissioner. We haven't called any traffic evidence to say one way or the other, but that would be consistent with what we see on campus.
I guess just to follow that up, because I had put down, do you have statistics on how many students have cars, but the hostels are there for the first year students, are they?
Largely, yeah.
Now, Mr. Page, we had earlier this afternoon presentation from Health New Zealand, and they've engaged Brendan Shanks, acoustic expert from Marshall Day,
Yes.
because they had concerns about the vibration standards as well.
Yes.
And Mr. Shanks has drafted an alternative rule, and he's now liaising with Mr. Exeter from Styles Group on the wording of that rule. So, Mr. Rawson, if we could just provide to Ms. Taylor the outcome of their further consultation and their agreed wording, because I think it's only appropriate we give the university an opportunity to look at and comment on the wording they come up with. And then, yes, and then Ms. Taylor, if you are able to then review that wording and provide to Mr. Rawson any concerns or comments you have on it, whether they be agreement or disagreement, and then that can all be relayed to us in the reply report.
Happy to do that, just realising that the scope of university's evidence was more about the within their site rather than the limits and
Yeah, no, that's okay.
Yeah.
I'm still interested in your view. I mean, the issue of vibration
happy with that.
and how it affects buildings within the same site under the same ownership is a matter that Health New Zealand is also interested in. So.
Okay.
Mr. Rawson, I've just noticed that just the diversion on page 20 of 22 of Mr. Shank's evidence. Can you just quickly open that up? Yeah, 22 pages, and I want you to look at the 20th page. Yeah, and just at the top of the 20th page, there's the bottom of a table, and then there's Roman numerals I. Do you see that? Top of the 20th page, it's just the tail end of a table that says in buildings part 3, and then there's Roman numerals I under that. And it says, except that the standard does apply. I think that's probably, it should be, it does not.
I this is just a very technical rule of on face value without my opinion.
Yeah, of course. I just want to draw to your attention. I think that's an error, and
Okay.
can you make sure that the experts confirm that it's an error? It should say does not instead of does.
Okay.
That's all. And that particular clause that Mr. Page is about an exception saying that the standard, the vibration standard in the German standard doesn't apply to vibration received at the building on the same site as the construction and site investigation activity. So it's the issue that you've brought to our attention. So.
Yeah, thank you.
Just in terms of your comments on the vibration, so is it your submission to us that the German standard adequately deals with the avoidance of damage to buildings?
Of any damage to buildings, yeah.
Okay. But notwithstanding that, the university doesn't want that German standard to apply to buildings within the campus of other construction activities going on in the campus?
Correct.
So why is that
if it's on the same site?
Why is that if you're confident that the German standard is appropriate? Why shouldn't it apply?
Well, so there's two issues with the German standard. The first one is what it's designed to protect. And so that's the degree of damage to a building. And so we say for heritage buildings, the public interest is not in the superficial damage. That's an inter partes civil matter. Mm-hmm. So we say that if what the reporting officer is getting at in the Section 42A report, which is that people who don't care about buildings might bowl them over using vibration, if that's the issue, then the vibration standard is at the wrong level. And as I said in my submissions, that's kind of like earthquake stuff, which is managed under the Building Act anyway.
Yeah.
So that's the first issue. And the second issue is that if you are going to, so it's the threshold, is it being pitched at the right place, and then there's a second issue around what's the council's interest in own site vibration.
Yeah, see, I guess what I'm not understanding is that I understand your submission to be that the threshold or the limit is set at the right level if the German standard is applied, but notwithstanding that, the university doesn't want to comply with that threshold or standard for its own activities. So to me, the two don't marry up. On one hand, you're saying, yes, it's a good threshold, that's what should be used, the German standard, but you're saying, but notwithstanding it's a good standard and we're happy with it, we don't want it to apply to us.
Well, if what the German standard is directing at is protecting a heritage building that is also sensitive to vibration, and I don't know how we know whether it is or it isn't, and you're dealing with the risk of damaging somebody else's building, we don't have a problem with it. We have a problem with the threshold if what you're trying to do is protect it from substantial damage that would engage Section 6B, and we have a problem with it being directed at the university's own buildings. So if somebody else was conducting vibration across the road, not the university, then the standard would be appropriate to protect the buildings from any damage at all, because that's an inter partes civil matter.
Yeah,
I'm not sure, the body language tells me that I'm not quite getting your point.
No, I think you've got my point. I'm not convinced that your answer is appropriate in terms of if the university accepts that the German standard is an appropriate threshold, I'm still failing to see why it shouldn't apply within the campus to intra-university activities. You can't on one hand say, yes, it's a good standard, we think it's appropriate, but then say, but we don't want it to apply to us.
But the standard is designed for a certain purpose, and what the reporting officer is promoting its use for is not the purpose for which it is designed. The purpose is designed so that you don't break someone else's building. It's not so that you don't break your own building.
So where in the German standard does it say that?
Well, that's the advice from Styles Group, is that they don't support its use for heritage buildings on the same site. because the standard is designed to protect the building from any damage. And we're saying the any damage threshold is not the right threshold to be applied through this plan change, because the purpose of the plan change is to stop people knocking over their buildings some kind of demolition by neglect argument.
Right, well, I don't think I can take that any further with you. Any other questions?
Well, I'll just sort of continue along that line then. You're saying that there are other protections in the plan that stop you from putting so much vibration into the system that you will actually bring your own buildings down and cause actual structural damage. So that this standard is only protecting against superficial damage which can be repaired. I should just get part of that sentence. And therefore the owner, being that they are both parties, has a different position for requirement for protection than if there were two separate owners.
That's right.
Is that effectively?
Because the university might decide, look, it's going to cost us $1 million to do a whole lot of vibration testing work, or it might cost us $100,000 to fix some wall linings.
And I guess that was the question. The question is, what's the burden that you are worried that you're going to get put upon you, and that is that you would have to do testing for vibration, which you would perceive that once you've done it, you'll demonstrate that you may cause minor damage, but you're not going to cause any structural damage. And therefore, why would you done the testing in the first place? Because you're familiar with the buildings and familiar with the buildings.
The likely scenario is that we're in the middle of a construction project on campus. The contractor is measuring vibration for insurance purposes. They down tools and say, hello, we're more than 2 millimetres per second now, so you guys go off and get a resource consent. Anybody familiar with a hospital project knows what happens when your contractors down tools and go away. I mean, those are very big numbers to have to deal with in the middle of a construction project. Absolutely. That's the logic of the rule, is that the moment that you've got an exceedance, you down tools and apply for a resource consent.
Thanks.
All right. Ms. Taylor, what do you want to say?
I will just quickly I'll go through my summary, but you know the issues. Phil's already covered them. And I discuss within my evidence the two remaining matters for the university.
Yep.
The first one is the HT provisions as they apply to the campus zone in terms of student hostels only. And as I just outline in my evidence, in my opinion, student hostels in the campus zone should be excluded from being subject to the HTG thresholds in Appendix C, and thus the rules. This is because requiring student hostels in the campus zone, which are currently controlled activities, is not to now seek a restricted discretionary activity resource consent is not consistent with the relevant strategic directions or purpose of the campus zone, which we've traversed before, which is to provide for the efficient and effective operation of campus-related activities. In addition, the matters of control attached to student hostels, which are in Rule 6.9.1.1 of the district plan, will ensure that the effects on the safety and efficiency of the transport network and accessibility will continue to be assessed and considered for any such application. So that's the overview of the HTG rules. The second matter relates to recommended building damage vibration rule. And I consider, by way of an exemption, which I've provided in Appendix 2, this rule should not apply where scheduled heritage buildings and structures are located on the same land holding as the proposed construction activity. And this is, as a summary, because the heritage provisions of the 2GP appropriately provide for the protection of the protected parts of scheduled heritage buildings and structures. Council's own vibration expert does not support vibration limits applying to buildings on the same site. And the need to seek a non-complying resource consent for minor damage that may arise from the exceedance of the proposed limit is not an effective or efficient approach under the RMA. And as I said, my suggested changes are in Appendix 2 of my evidence.
Yeah. All right. Do you have any questions? Yeah. Sophie, any questions?
No.
Just now, just for your information, Ms. Taylor, when the work that Mr. Shanks and Mr. Exeter are doing on this possible new vibration rule, you need to pay particular attention to the following provision. It's 4.5.4.x bracket B bracket Romans 1.
Okay.
And hopefully they don't change the numbering. But if you look at Mr. Shanks's evidence, which is available on the webpage,
Yep.
you'll see the current wording in that provision, and you'll be able to see if the thing that comes through to you has changed the numbering, you'll be able to see what that provision has moved to. But I think that's the provision that'll be of most interest
Thank you.
to
Yeah.
the university in terms of the issues we've traversed. Just 1 minute. So you're recommending an amendment to Appendix 6C. This is in your Appendix 2.
Yeah.
To the supported living facilities.
Yeah. Student hostels are a subclass of supported living facilities, so that's the reason student hostels are currently court captured
Yeah.
by the proposed rule.
So in terms of the wider campus activities, they're not captured by the high trip generating threshold because why again?
Because of the main one is the definition, and I have it in a footnote somewhere in my evidence. The definition of training and education facilities
Yep.
excludes campus-related activities.
Okay. So it's the because training and education is an appendix
That's correct,
C
isn't it, Phil?
matter, and that's defined as excluding the university.
Yeah, there's a list that excludes
Okay,
campus-related
that's how that
activities.
All right.
Mr. Copeland in his evidence also noted that.
Okay. Okay, well, that's all I wanted to ask you about. Thanks very much for that. Anything else to say by way of closing comments, either of you?
No?
No?
No.
I think we've had a good traverse of the issues. Thank you very much for your evidence and legal submissions and for answering our questions. Appreciate it.
Thank you all.
Thank you.
Right, now in terms of the overall hearing, that brings us to the end of hearing from submitters. So, Mr. Rawson or Ms. Christensen, is there anything that either of you wish to say at this stage?
Just a query with any other questions from the panel. All the
I don't have any questions in mind. I think we've asked you things as we've gone along and asked you to follow up in the reply report. Off the top of my head, I can't think of any additional matters. Do you have any additional matters? Okay, no, I think as long as you've recorded the things we've put to you, which I've seen you've been typing as we've talked, then we look forward to getting the reply report. And just in terms of timing, we discussed that earlier in the hearing, but you're still aiming for the 5th of September, is that correct? All right. Absolutely, and if you need more time, just let us know. We won't have an issue with that. We'd prefer you take more time and do a thorough job rather than rushing to meet in a relatively arbitrary deadline. Yep, so don't be afraid to ask for more time if you need it. All right, well, to everyone who's participated in the hearing, and if anyone's still watching on Zoom, thanks very much for your attendance and your assistance. We appreciate it, and we'll adjourn the hearing now till we receive the right of reply. At that stage, if we don't have any further questions, which I suspect might be unlikely, we will then close the hearing Rebecca, you wanted to say something? Oh, we do too. I forgot about that. Thank you for reminding that. We are hearing from the Port of Otago next week, so we will adjourn the hearing pending that, hearing that submission, which is going to be on Zoom, so it'll be a virtual hearing. Will you be here in person, Jim and Sophie, or are you all going to, we all going to be in Zoom?
But I mean, if it's going to be on Zoom, it might be better for all.
Yeah, so,
You've got a
Oh, you booked a room? Okay.
We'll be in the council chamber.
okay, so apologies, I forgot about that, my mistake. So next Wednesday, we're hearing from the port. I'll be sitting in Napier, so I'll be coming in on Zoom, and the other two panel members will be in the council chambers. Following that presentation, we will then adjourn the hearing pending the right of reply. Thanks, Rebecca. Yeah, fuel. Good save. All right, thanks everyone.
Cool.